Right, hello once again, my fellow Supreme Court history buffs. The word fellow was cut off in the previous video, as were several other words. So I had to emphasize it this time, and I have to apologize for any other words that were not audible properly in the previous video. I am not using state-of-the-art equipment, and I hope you will bear with me until I get the setup right, until I get used to these recordings. Anyway, this video is about the judgment in the A.K. Gopalan case, the actual judgment, what was held by the bench. And it's hopefully going to be a pretty short one. I'm only going to discuss what was held and not the implications of what was held. The analysis of the judgment, I'm keeping it for a later video. So let's, before looking at what the bench held, let's remind ourselves who the bench was. For a change, we have an image of the bench. It's not always that I'm going to have an open source image of the actual bench. In fact, it's almost never that we are going to have an open source image of the bench available. But in this one, this is of course taken during the inauguration of the Supreme Court. Chief Justice Harilal Kania and Justices Sayyid Fazal Ali, Patanjali Shastri, Meherchand Mahajan, Sudhiranjan Das and B.K. Mukherjee, 6-member bench. It is a rare sight to have an even numbered bench in the Supreme Court. It is an even rarer sight to have a full bench of the Supreme Court hearing a particular case, and this is what they held. First of all, Article 19 has no application to preventive detention laws, as was successfully argued by the Attorney General on behalf of the state of Madras, and therefore Article 19(1)(d) cannot be violated by preventive detention laws. In short, preventive detention is no different than punitive detention as far as Article 19 is concerned. Further, Article 21 does not imply any reasonable procedure. It does not imply, therefore, due process, and that is neither procedural due process nor substantive due process. Article 21 is restricted to the words present in it, that is, no person can be denied of his life or personal liberty except by the procedure established by law. All was not gloomy. Section 14 of the Preventive Detention Act 1950 was held to contravene Article 22 Clause 5 of the Constitution. Let us remind ourselves that Section 14 allowed the government to withhold the grounds on which a person was being detained, and also prevented the courts from hearing the grounds of grounds under which the person was held. This, of course, contravenes Article 22 Clause 5, which goes like this: when any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made. And we saw that the Preventive Detention Act 1950 allowed the government to not disclose the grounds if that person was being detained in fear of him acting prejudicial to certain certain clauses, certain reasons, such as the security of a state and the defense of India and the relations of India with a foreign power, etc. So, although Clause 5 of Article 22 of the Constitution specifically says that grounds shall be communicated, the Section 14 prevented those grounds to be communicated, and this was unsurprisingly held unconstitutional. This was unsurprising because even during that slapdash one-day session where the act was approved by the parliament, one of the members of parliament, Mr. Hari Vishnu Kamath, had warned the government, had actually moved an amendment to that preventive detention bill to remove this particular article, to reword it, and to prevent the government from withholding the grounds of arrest, of detention. Mr. Kamath is a very interesting personality. He had qualified for the Indian Civil Service examinations in 1938, but had instead chosen to join the freedom struggle. He was a member of the Forward Bloc party, of course, to which Netaji Subhash Chandra Bose belonged. And Mr. Kamath's prediction that this provision would be held unconstitutional was proven to be accurate. The bench then found that although it was unconstitutional, that particular provision could be detached from the rest of the act, and the rest of the act could be saved. There was no need to hold the entire act unconstitutional just because that one provision was violating Article 22 Clause 5. This particular measure is known as the doctrine of severability. Severability, something which can be severed, something which can be cut away, something which can be detached. And Section 14 of the Preventive Detention Act was found by a majority of the judges of our bench to be severable in such a way, which meant that if Section 14 is removed, the entire act does not collapse, which is a pretty accurate interpretation. There is hardly anybody who would criticize this part of the judgment. The rest of the judgment, though, especially what we saw in the previous slide, that Article 19 is not contravened, Article 21 is not contravened, and consequently Article 19 and 21 are not related, they are distinct pieces. All of these points held by the court were criticized roundly, but they remained the law of the land all the way until 1978. And the implications of this is what we will discuss in the next video. The implications of that, as well as the implications of the removal of Section 14 from the Act. That is basically what the A.K. Gopalan case had achieved for Mr. Gopalan. The Preventive Detention Act 1950, on the other hand, remained on the statute book. So that's a quick look at what actually was held, what it all implied, what were the ramifications, what it all entailed. Let us look at that in the next video. Hope to see you then. Thanks. Bye-bye.